Hello, my name is Jackie Roundtree and this is my partner Olivia Turton. We're going to give a short presentation on the Small Claims Court. The Small Claims Court is probably the best and the easiest way to obtain payment from a defendant in a quick and reasonably cheap way. The Small Claims Court is for everybody, not just the businesses.
The Small Claims Court can be used for contractual consumer problems. It is a quick and usually effective way to deal with small or low value claims such as retailers not taking responsibility for faulty or damaged goods, going against the Consumer Rights Act 2015. The Small Claim Court now deals with claims of up to a maximum of £10,000 against a firm or an individual within England and Wales. However, if a claim is above the limit, the claim will be relocated to a different track within the county court. There are two types of tracks beyond the small claims, multi-track and fast track. To follow up these claims outside the small claims will result in a longer process that can be a lot more expensive. If the claim you are making is based on contract, then 6 years from the date of the breach of contract is the maximum time limit for you to make a claim. Although there can be exceptions. For example, if the contract is in the form of a deed, the period can be extended to 12 years. You can claim up to £10,000 if you have been injured. Only £1,000 of the amount can be for injury. The rest of the money could be for compensation. An example would be if you were unable or unfit to work, you could claim for the loss of earnings. You must make your injury claim within 3 years. There are a few exceptions to the 3-year rule. One which includes if you were under the age of 18 when the accident happened. The second is if at the time of the accident you did not know you had been injured as a result of illness or disease. A solicitor will be able to explain in further detail.
The cost of taking the court action can be very expensive. The cost of lawyers, barristers and experts are usually financially beyond the average person. And although the Small Claim Court does away with much of these costs, and it's not essential for a solicitor to be used, it should be noticed that you may find that the person you are suing can and may employ one. However, most claims are made personally without the need for a solicitor and are therefore cheaper, quicker and less formal. There are costs involved, and it's a good idea to ensure that the cost of making the claim is worthwhile before you go to the time, cost and the emotional stress of taking the matter to court. It is also a good idea to check how likely you are to get paid if you win the claim. If the person or company you are claiming against has no money or is experiencing financial problems, you will not get your money back. And if your claim is against a business that is no longer trading, you will not be able to take them to court. You have to pay a fee to make a claim. The amount you pay is based on the amount you are claiming. And for example, if you're claiming £5,000, the cost will be £455. You may also have to pay other fees, including the cost of an expert to assess your claim and the cost of a solicitor if you choose to use one. If you win your claim, you may get some of these costs back from the person you are suing. However, it should be noticed that if you lose, you will have to pay these, and you may also have to pay the costs incurred by the other side. Before you make a claim at the Small Claims Court, there are steps that need to be taken and rules that must be followed. These are rules made by the Ministry of Justice and include the civil procedure rules and practice direction on pre-action conduct. If these rules are not followed, the judge will take this into account when making his judgment. The civil procedure rules ensure that each case is dealt with fairly, and therefore the following matters need to be adhered to. Basically, you're expected to cooperate fully with each other, and the rules ensure that both sides are on an equal footing. Both sides are required to give the other side all the evidence they will be using, and methods to solve the case outside of the court called alternative dispute resolution have been used. These can include arbitration, mediation, using ombudsmen or trade associations, and it needs to be shown that both sides have tried to settle the claim before going to court. All costs must be kept to the minimum possible so that the way the claim is presented refers to the amount of the claim, how complicated the claim is, and the financial position of both sides. If these rules are obeyed, the court hearing should be shorter, cheaper, and the outcome more certain, and this avoids the judge's time being wasted. The most effective way of ensuring that these rules are adhered to is through mediation.
Mediation is not mandatory and can be a useful and effective way to settle claims out of courts. As mentioned, mediation isn't mandatory, but after you have made a claim, you will be asked whether you would like to be referred to the mediation services. The mediation service is a free service. The mediator is not a judge, and his role is not to decide who is right or wrong. The mediator is skilled in negotiations and to help both parties in disputes and to reach an agreement. If someone is thinking of going down the mediation route, it is better for mediation to take place sooner rather than later. When a defence has been filed and a claim can be settled, it means you can avoid the need to prepare, for example, witness statements, which saves the court's time and expense. Generally, you should try mediation as there is no cost to you. If you refuse to try mediation without good reason, then cost penalties could be made against you. An agreement or an apology is often the outcome of mediation.
However, if after all methods of alternative dispute resolution have been tried and no agreement has been made, then as part of the pre-action conduct you need to write a letter explaining that you intend to take the matter to the Small Claims Court, and you also need to complete Form N1 to carry out a small claim. The court will then send a copy of your claim form to the defendant. If the defendant doesn't reply, the court can decide that you've won the case and award in your favour, and this can be done by requesting a judgment by default. If the defendant agrees with some, but not all of your claim and offers a part payment, they can do this by advising the court accordingly. The court will send a copy of their offer and Form N225A. If you accept the offer, you need to fill in the form and return it to the court by the specified date. However, if the defendant disagrees with your claim, they must explain why in a document called their defence. And this is known as defending the claim. The judge might feel that there is no need for a court case if they, for example, feel either side doesn't have a strong enough case, or they feel it can be done without a hearing. They can ask if you and the defendant agree that the court can make a decision without the need for a case, and the judge will then make a decision based on your claim and the defendant's defence. This avoids the need for going to court or having to give any further evidence.
If it is decided that a court case is needed, a date will be set and you will need to attend. The court will tell you what you need to do before the case. These are called the directions. You will need to send copies of the documents you're going to use to the defendant, and you also might be asked to write a witness statement. A witness statement is a document that gives all the information that you want the court to know about the case. It will also be necessary for any witnesses you are going to use to also write one. You do not need to have a witness, but it can be useful if there is an important fact that they can give evidence on. If you have been injured, you will also a doctor to give their opinion on your injury and how well you will recover. You could also use an expert to comment on poor or dangerous workmanship. You will need the court's permission to use an expert and will have to pay for it. It should be noted that if you feel that you need to use an expert, the defendant must agree with the choice. If you disagree with the defendant's evidence, you need to prove that what they're saying is incorrect. If you have any evidence or have the witnesses to prove they are wrong, this needs to be provided to the defendant and the court. When all the evidence has been submitted, the judge will read these. At the court case, you might be asked to summarise your claim, and both sides may be asked questions. It is wise to think beforehand about how you'd like to present your case, as it needs to be clear and not take too long. The judge will give his judgment at the end of the hearing and will explain his reasons for his decision. If you win, the judge will order the defendant to pay you. You may be awarded all or just some of the amount you claimed. You and any witnesses may also be awarded expenses such as court fees, travel expenses, and any awards towards any lost earning. You may be awarded up to £750 towards the cost of any experts you may have used, and some cost towards preparing the case. If you lose, you might have to pay the defendant's costs and will also any money you have paid. If you do not agree with the court's decision, you can ask the court for permission to appeal. You will only have 21 days from the date of the judge's decision to make an appeal, and there are costs involved in this. The main advantage of the Small Claims Court is that it's inexpensive, a cheap way to settle a dispute. As mentioned, the maximum the Small Claims Court can now deal with is up to £10,000. The filing fee is much lower, cheaper than any regular civil court. The other main advantage of the Small Claims Court is it isn't time consuming. It is a quick process and can be majority of the time straightforward depending on your claim. You'll get a hearing not long after you have filed your small claim. Small claim courts hearings tend to be fairly informal also. You'll of course have to provide contracts, invoices to prove your case, but there is no evidentiary technicalities. Disadvantages you can make.
The main disadvantage is that you can make a claim of only up to £10,000, and obviously, although you may be able to keep your cost to a minimum, the defendant may have a solicitor, which will cost, if you lose, will cost you a lot of money. This includes our presentation, which I hope you have found interesting.